That isn't what we have here.
Well, setting aside, really, say, all of our case law, because as my concurrence sort of struggled with, there's been very little kind of comprehensive thought in any of these cases about this issue. It's more just data points over the past century and a half. Why isn't it inherent in the nature of the judicial power to have some limit on the kinds of cases courts can hear based on some kind of injury and redressability of that injury in a particular case?
Well, and to some extent, and obviously we're getting into much broader questions than this case encompasses, to some extent I do agree with you that it is there. It's a question of the type of case and the ability of the legislature through legislative enactment to expand it. There clearly are certain aspects of it that are, by the Constitution, conferred upon the legislature. 5 years ago, the jurisdiction of this court and the Court of Appeals were changed through an Appellate Procedure Act that
Because the Constitution said, unless otherwise
that is
provided
correct.
by law.
That is correct. Here we don't specifically have unless otherwise provided by law. We do, however, have in Article 3, Section 6, Paragraph 5, a specific list of powers that are denied to the legislature. The General Assembly cannot legislate in certain areas.
But there's still a question of what the judicial power, what that means.
Right.
We have precedents. Justice Peterson laid a lot of those out. They tend to help you. Why isn't there a common law background for the judicial power as well? I mean, that phrase has been in our constitutions for a long time.
Right.
I mean, some limits that we seem to follow as to justiciability seem to come from the common law.
And my only estimate of why that's the case, Your Honor, is because over the course of the time that we have had state constitutions, we're talking about a period of time that begins around the time of the 1784 Act of the General Assembly that incorporated the common law of England as the law of Georgia, which of course is still by statute in Title I, and which this court has relied upon in decisions in recent years. I mean, it was effectively codified the existence of the common law as it existed.
Right, it codified the common law.
Right.
But there's also constitutionalization of the
Right.
common law.
Yes.
For example, the self-incrimination clause, which we've said is the constitutionalization of a common law right. And a common law, as Justice Thomas's concurrence in Spokio points out, it seems to be the opposite of where, and I think Justice Peterson's concurrence mentions, seems to be the opposite of where Georgia is, that private rights were very expansively allowed standing, but public duties, you could only go, private citizens didn't have a right to go enforce public duties.
Fair enough. We do, of course, still have, both in the Constitution and statutory law, the rights of citizens, which would specifically refer in this case, in the Newton County case, to Ms. Humphreys, who is a citizen and a taxpayer and a resident of Newton County. As it relates to the defendants from the Sons of Confederate Veterans, they include the overall.
But it appears that common law,
Right.
a citizen couldn't go in and say, I demand this law be enforced, because at common law, and as a matter of separation of powers, the enforcement of the law is usually up to the executive.
Right.
The king or the president or the governor.
Understood. And all I can say to that, Your Honor, is that the law has, the statutory law of Georgia has changed upon that point as more and more statutes, including this one, have been enacted that effectively authorize private attorneys general. We cited a number of cases or a number of statutory schemes in our briefing, but actually I believe in retrospect the better analogy probably would be to something along the lines of the Open Meetings Act or the Open Records Act, both of which in OCGA 5014-5A and 5018-73A refer to giving jurisdiction to the superior courts to hear actions that include granting civil penalties that can be brought by the Attorney General, but also can be brought by, as both statutes put it, any person, firm, corporation, or
Well,
other entity.
in the open records context, they can only be brought by someone who made a request for records and was improperly denied, and so that person clearly would have some articulable injury. I think your argument's probably stronger in the open meetings context, where if a agency that is subject to the act holds an illegal meeting, I don't have to have sought to attend the meeting. I don't even have to live in the jurisdiction of the agency in order to file that particular lawsuit.
Correct, Your Honor.
Can I ask a slightly different question that I don't think has come up in the briefing? The nature of our case law about relaxing the individualized injury requirement to bring a suit seeking to enforce a public right. Those cases typically talk about taxpayers, they talk about citizens. What is the authority in our, and presumptively that would apply to Humphreys.
Correct.
What case law supports the idea for an association to bring those claims?
Sure. Well,
in its own name?
And again, Your Honor, I would refer back to the Open Meetings Act context, where 2 years ago, this court in Williams versus DeKalb County, 308 Georgia 265 at page 276, indicated this provision plainly contemplates that a private person or firm, corporation, or other entity can bring an action
I'm
to
not talking
enforce
about
the act.
statutory text.
Sure.
I'm talking about our standing precedent.
Understood.
If the whole rationale for why a person can sue to enforce a public right is citizens and taxpayers have a particular interest in the law being, enforced, what in our standing precedent extends that authority to a non-individual association suing in its own name?
Certainly.
Other than an associational standing theory that we've imported wholesale from the Article III context.
Right. And Your Honor, I would go back to your concurring opinion in the Black Voters Matter case. I believe it'd be under Section 2 of the concurrence, 397 and 398, that you indicated that beginning in 1897, there was a consistent holding that citizens and taxpayers, as you say, may sue government officials to enforce publicly owed legal duties and to contest their ultra vires act.
Is Sons of Confederate Veterans a citizen or a taxpayer?
No, Your Honor.
Okay, so why does Sons of Confederate Veterans have standing to assert a public right under that theory?
Understood, Your Honor. As you went on to say, by the adoption of the 1933 Code, that rule was codified in statute in what is now OCGA 9624, which currently says, where the question is one of public right and the object is to procure the enforcement of a public duty, no legal or special interest need be shown, but it shall be sufficient that a plaintiff is interested in having the laws executed and the duty in question enforced. There's no reference specifically to citizens or taxpayers there.
So I'm not sure that the statute necessarily does a whole lot of work here, because it seems to me that if standing is a jurisdictional doctrine, which we've said it is over and over again, then standing has to have some sort of constitutional authority behind it. Because generally speaking, jurisdiction is subject matter jurisdiction of the kind that we've said standing is, which goes to the power of the court, generally is of constitutional dimension. So the fact that a constitutional principle may be enacted into statute in a particular form doesn't mean that the statute defines the scope of the constitutional doctrine, right?
Understood, Your Honor. And I'm certainly not going to argue with you about what you meant in your concurrence.
Well, and look, a concurrence is one judge's view. I think Justice Warren joined the concurrence. The concurrence is not the law of Georgia.
And I understand
And it
that,
didn't
Your Honor.
arrive at any conclusions. It basically just said, look, there are a bunch of questions that I have.
Right. Well, I think you don't give yourself enough credit. It did arrive at some conclusions. For instance, that standing is certainly required if you are challenging the constitutionality of an act. Again, that's not the case that we have here, but there's longstanding case law based on the Georgia Constitution or the Georgia constitutions and provisions that have remained there throughout. But to answer your specific question about the legislative power, I'd go back to the limits on the legislative power, and specifically the breadth of it, that under Article 3, Section 6, Paragraph 1, the General Assembly shall have the power to make all laws not inconsistent with this Constitution and not repugnant to the Constitution of the United States, which it shall deem necessary and proper to the welfare of the state. And clearly, there are some specific constitutional grants of authority to the legislature to affect the jurisdiction of the courts. There are also, obviously, what we talked about with the appellate practice. Again, that has a very specific grant of authority. But there's also, as this court ruled over 100 years ago in Harris versus Sheffield, 128 Georgia 299 at page 303, the courts have power to decide these questions not because the subject matter is inherently judicial, but because the jurisdiction is conferred by the legislature. Now, again, that is not a power that is utterly without any fetters on it at all, although this court has indicated that there
doesn't
is
the
a
separation
law.
of powers clause prohibit us from exercising a power that is not judicial?
It does,
The
but
powers of government are in three categories, right?
Correct.
There's executive power, there's legislative power, there's judicial power.
Sure.
We're prohibited from exercising the power of any other branch.
Correct.
If the General Assembly passes something that purports to confer on us a power that is not judicial, that means it has conferred on us a power that is either legislative or executive,
Correct.
which
They can't do.
they can't do.
Correct. But, Your Honor, they do have the ability, at least within a certain scope. I'm not arguing that it's completely unfettered, but within a certain scope to address the jurisdiction and to confer standing to a certain extent. Again, I don't, it's beyond the scope of this case and certainly above my pay grade to be able to address the larger philosophical issue. But the ability of the General Assembly to say there are certain public goods that we're going to allow private individuals, not just private individuals, but also private individuals and entities to enforce for the good of the public. That doesn't seem to be a controversial concept in the Open Records Act or the Open Meetings Act. And that's essentially what's being done here.
It's less difficult to say there's some kind of injury when the law is not being enforced, because you could say that every citizen at least has an interest, is hurt
Right.
when the laws are not enforced. The trickier part is the federalized, individualized injury that says it's not enough that you're hurt.
Damages, no, you are doing something that violates the law. We are bringing this action under 53(1)(b)(5), and if we succeed, we then have to put that money back into the intended use to benefit the public.
And I know these questions are still stranded down at the trial court level, but that also potentially creates some very interesting home rule questions underlying this, because you're then clearly accessing government property. I mean, the local government is going to have to, I guess, accede to whatever it is you want to do to repair or replace in that eventuality, right?
That is correct. And again, obviously, if we get to a hearing before a finder of fact, the issue of damages, what would it cost to replace or repair the monument, that's going to be there, just like the reasonableness of attorney's fees.
Well, I don't mean just the cost of repair, but that if you say you have to spend it for repair and replace, in I think both of these instances, you would have to have access to government property, and under what authority would you have the ability to do that? Those are other really interesting questions that aren't here today.
You are correct, and Mr. Jogstetter and I were talking about this beforehand, that, as I hope we do, if we prevail today, we go back to the trial court, and then we have an argument over sovereign immunity that'll probably make its way up to the appellate courts in the future as well. But as far as the question here today, I don't know the full scope of standing. I certainly understand and respect this court's desire to carve out a standing doctrine that is based on Georgia law rather than on federal precedent that may or may not be applicable. All I can say with respect to this case is we are in a situation where we are enforcing a public right that is for the public benefit. Again, the policy question is one that reasonable people can disagree about, but the policy clearly has been set by the General Assembly, and it allows private individuals to act in preservation of not just Confederate monuments, but all sorts of monuments to our heritage and our history, including all social, political, and civil rights movements. So there's a much larger context for this particular fight, much as there is a much larger context for this particular question. All I would say is that given the existence of the Open Records Act, the Open Meetings Act, and the fact that these damages have to then be used for the benefit of the public does create enough of an injury that for the specific appellant, the specific plaintiff, that this statute is within whatever standing limitations the Constitution does.
Just circling back to the question I'd asked before to
Yes.
try and get a precise answer on this point. What is your best case under the public rights standing line of precedent from our court that the Sons of Confederate Veterans associational plaintiffs have citizen or taxpayer standing under that line?
I think I would rely on Plum versus Christie, 103 Georgia 686, about the expansive authority of the state legislature in such matters. And then beyond that, I would fall back to the cases that were cited before. And I apologize, I have moved things around here. I'm sorry.
You can finish it, answering
right.
the question.
And I would say beyond that, the Williams versus DeKalb County decision, 308 Georgia 265, with respect to the Open Meetings Act. Thank you, Your Honor.
Thank you. Mr. King, Mr. Jogstetter.
Good morning, Mr. Chief Justice, members of the court. My name is Patrick Jogstetter. I represent Newton County, Georgia. Taylor Hensel at the table beside me represents Henry County, Georgia. I'll be handling the argument on behalf of all the appellees today. I want to start this morning by reminding the court of something that was brought up earlier in questioning. Article 1, Section 2, Paragraph 3 of the Georgia Constitution provides that the legislative, judicial, and executive branches shall forever remain separate and distinct. And what that means, I would suggest, is that a judicial power can be exercised only by the judicial branch. Legislative power can be exercised only by the legislative branch. If one branch can exercise it, no other branch can. That's what keeps those powers separate. I would also like to remind the court of Article 6, Section 1, Paragraph 1 of the Georgia Constitution, which provides that all judicial power shall be vested exclusively in the courts. And I think that's really what this question is about, is the determination of what constitutes standing. Is that a judicial exercise or is that a legislative exercise? I think that's what the court's question to us really boils down to.
If it's a wholly judicial exercise, is the Open Meetings Act unconstitutional?
Let me address why I don't think it probably is. Because of the nature of the relief sought. So the nature of the relief sought under the Open Meetings Act, different than the nature of the relief sought on the Monument Protection Act is penalties. Under the Open Meetings Act, you're not allowed to sue for damages. You can only obtain a civil penalty. And that civil penalty is,
So before we get to redressability and causation, let's talk about injury. The Open Meetings Act does not require a plaintiff to have been uniquely injured in any particular fashion. And in fact, in most cases, it would be very, very difficult. I mean, the only real way you could be uniquely injured is if you're on the agenda and you're voted on in an illegal meeting.
right.
If Article 3 standing applies in every case in Georgia courts, it is hard for me to see how that would be constitutional.
I don't suggest that Article 3 standing necessarily applies in every instance. This court has carved out its own set of rules with respect to standing. This court has done that. And the Open Meetings Act, I think, is in accord with what this court has recognized as taxpayer standing to enforce the performance of a public duty.
So one of the other exceptions we've carved out is the public rights enforcement cases.
Right.
Why, and you would acknowledge that that line of case law doesn't require an individualized injury, right?
That's correct.
Why doesn't this case fit within that line of cases?
Because of I think that really does boil down to the nature of the remedy sought. Those enforcements of a public duty are typically efforts to compel the government to perform an action that it is required to take, as opposed to this instance, which seeks to confer standing upon someone to recover damages. I don't think you can evaluate the applicability of standing rules to the Monument Protection Act without considering the language of the Monument Protection Act.
Well, if Mr. King is correct about what the act requires, the damages amount would not be sort of normal damages where you just get to take the money and put it in your bank account. You would be required to spend that money to do the thing that the government was allegedly required to do and didn't do in the first place, right?
I would suggest, I disagree with that interpretation of the statute. The statute contains no express language that requires any portion of the damages to be put to any particular use.
So in B4, it says, should a public entity, owner of the monument, or person, group, or other legal entity prevail in any action under this code section, such prevailing party shall timely pay for the cost of or repair or replacement of the monument upon monies being collected from the party damaging, destroying, or losing such monument.
They shall pay for it. They shall not do it on their own. I think that's where the difference is. So essentially what happens is the money must be paid, but interestingly, what that statute does not call for is any injunctive relief. That statute expressly does not.
So look, I think y'all may have all sorts of other defenses in this case.
Right.
I think there are a lot of other issues still remaining in this case. There's sovereign immunity, there is injunctive relief available. I looked at what you filed in the trial court. I didn't see any constitutional claim that the statute was unconstitutional under home rule, but it seems to me that there'd at least be a significant question about whether the statute's even constitutional to begin with. Right. But none of that is before us, because the only thing that's before us is the Court of Appeals ruling on standing. And the Court of Appeals held there was no standing on the basis of federal Article 3 case law. Now, I can't fault the Court of Appeals for that, because this court has been applying that case law for the last decade or two without really explaining why. And they don't get to chart their own course on that. But why is that right to do in Georgia court under Georgia standing doctrine?
I'll make an effort to describe why I think that is the proper. I think the Georgia courts have followed the proper analysis, although the reliance on Article 3 of the U.S. Constitution perhaps was unnecessary.
That's the only analysis we've ever applied.
Right.
We don't say, let's figure out what Georgia law is. Well, not in the recent decades. When you go back, we actually thought about our own Constitution and our own law more. But, the Court of Appeals and the trial courts here say, we've got this question of standing. Let's cite a bunch of federal cases about individualized standing. When you look at the federal cases, they all go back to federal law, and particularly the case and controversy requirement of Article 3, which we don't have.
And in fairness, that's how we've all done
Right.
it for the better part of a generation. But if we look at some specific provisions of the Georgia Constitution, I think it can yield an analysis that tracks the Article 3 analysis. The next section I want to point the court to, Article 6, Section 4, Paragraph 1 of the Georgia Constitution. provides, with respect to superior courts, jurisdiction, quote, in all cases, end quote, except as otherwise provided in this Constitution, is vested in the superior courts.
Why don't we have a case?
I'm sorry?
Why don't we have a case?
I don't know. I can't answer that. I think no one's ever made the argument this way before, frankly.
No, I mean, in this case, I mean, I asked the clerk to call the case.
Right.
We're talking about the case.
It
Okay.
has a case number.
So I think the way you get there, to complete my argument, Your Honor, is the standing doctrine out of Article 3. In Article 3 arises from the notion that the court exists to hear cases and controversies. The superior courts in Georgia have jurisdiction to hear cases. Does the exception, does the omission of "and controversies" change the nature of judicial power? I don't think it does. And what this court has done, and what courts in Georgia have consistently done, is define what it takes to be a case or a controversy. And that's been so with respect to this court since the 1800s. Since the 1800s, in a couple of cases cited in our brief, the courts have said that in order to be a case, I must have two parties with conflicting interests, and the parties must have a real interest in the case. And I would submit to the court that that is the same.
We say that, and then in the taxpayer and citizen cases, trying to enforce public duties, we say that all citizens for most laws, if it's a tax law or a monetary law, all taxpayers have an interest in making sure the law is properly followed.
And to the question that we were asked to address, which is essentially, can the General Assembly create standing that doesn't otherwise exist? The fact that this court has carved out those standing rules is consistent with the fact that the determination of standing is a judicial determination.
So we have a very long line of cases where we said that's the law, whether or not the legislature has specifically done it. And then we have a case here where they have a statute where they've specifically said any party, anyone with interest. I mean, query whether, the people defined if they weren't Georgia citizens or taxpayers, maybe that's beyond our case law, but how does this statute deviate from what we've said in a lot of cases about citizens?
And in answering that, also address where we have applied heightened standing rules in the constitutional case, we've said we do so for separation of powers reasons to stay out of the General Assembly's lane. It seems strange to say that because of a doctrine that is developed out of a respect for the General Assembly's prerogatives, the General Assembly lacks the authority to legislate.
So let me address that question first, and I'll work backwards. I think the General Assembly does have the right to legislate. And I think, I'm not suggesting that no one has the right to bring an action under 50-3-1. 50.
That's right.
3-1, yes. I'm not suggesting that no one can establish standing. What I'm suggesting is that in order to establish standing and in order to avail oneself of the protections afforded by 53-1, you must have standing to bring it into court. This is not our argument is not no one can ever bring an action under the Monument Protection Act.
So, counsel, let me ask it this way, and you won't find this, I guess, in any law review article, I suspect. But for me, standing is when someone comes to court, it's what says, you, court, have to pay attention to me, and this is the power I'm asking you to exercise on my behalf. Right. It's a simple way to me. I mean, it works for me. You keep saying this legislature can't create standing, and I don't necessarily think that that's wrong. But they can create the interest that gives you the right to go to court and say to the court, I have this interest, and you, in the exercise of your judicial power, are empowered to make it right. So why is that not what's happened here? The General Assembly has created an interest, wisely or unwisely, to the point I think your opposing counsel made, whether we think that was a good choice or not, they've created an interest and essentially given that interest to the universe and said, this is now your interest, and then courts in the exercise of the judicial power, you walk in the door. Why do I have to listen to you? Well, Judge, I have this legal interest, and the only place I can get it resolved is in a court. Right. Why is that not standing?
Because I think under the Monument Protection Act, what you're allowed to do is come into court and say, Judge, I want damages. Not just I want an ethereal, mythological, psychological enforcement of the act. I want damages.
Well, but counsel,
Damages.
if damages are the key thing, there was a very thoughtful amicus brief filed in this case by Georgia Watch.
Mm-hmm.
And essentially their argument is, look, if the Court of Appeals opinion is right, then all the consumer protection statutes in the state are potentially void. And those are statutes under which you get monetary penalties and damages. So how are the consumer protection statutes of the state viable under your theory? The consumer protection statutes that, allow private attorneys general to litigate without necessarily having been personally injured in the amount of the damage.
And I think the reason for that, what the distinction between the two is, those statutes authorize private attorneys general to bring those actions.
So does this.
This statute authorizes any person to seek damages, and interestingly, it
So if
doesn't
said
limit.
Any person, parentheses,
Right.
who we will call a private attorney general,
Okay.
close parentheses, then it'd be okay?
I think the difference is the statutory language. I think when the language says,
It's not referred to as private attorney generals in the other acts.
right,
either.
but those acts authorize actions to be brought on behalf of others. In order to recover damages, if I'm suing you for damages, I must show an injury. A damages is redress for injury. Damages doesn't stand alone.
Well, many of the consumer protection statutes have just statutorily defined penalties for various violations that don't necessarily bear a direct relation to actual injury incurred.
And I would suggest if the Monument Protection Act called for the imposition of a penalty, that might be different than the award of damages. And that's what the Georgia Open Meetings Act does. The Georgia Open Meetings Act specifically contemplates a civil penalty. The Monument Protection Act authorizes damages. And I think that under the Civil Practice Act, or under the Open Meeting Act, you
I
need
think-
not,
Doesn't that go more to perhaps their difficulty of proving damages? I mean, when a statute simply says, you can sue for damages, whether or not you've actually been injured in a Article III kind of way, you still have to prove damages. And so you don't have the ease of just saying, well, there's a statutory penalty, and so that's $3,000 an act, and please give me my $3,000. That may be a proof problem they have, but I'm not sure why it's a standing problem.
because if all you can do is recover damages, you must have suffered an injury. Damages exist only to redress injuries. Step one in any claim is there must be a breach of a duty that resulted in injury. Step two is damages are awarded to compensate for that injury. And what we're suggesting is these plaintiffs have not established that the arguable breach of the legal duty, and we're not willing to concede that we breached the duty, but
If that's the case, then counsel, going back to the earlier exchange, how in the Open Meetings Act would I define damages?
the Open Meetings
In
Act
the context
calls,
of an Open Meetings Act, how do I define quantifiable damages?
well, the Open Meetings Act authorizes an award of a penalty, a civil penalty, and I
So
think
would it
that
be unconstitutional for the Open Meetings Act to authorize the award of damages?
in the absence of an injury, I think arguably so. I don't think.
But is that because of standing reasons, or just because damages inherently are, payment for an injury you have suffered, and if you haven't suffered an injury, you're going to have zero damages? I mean, I don't know that that's you can't come into court. It might be you can file your lawsuit, and then, the jury or the judge, if it's a bench trial, returns a verdict with a zero on the damages line.
I think it is a matter of damages. If I see a car wreck on the street and I file a lawsuit saying I saw driver A run the red light and smash into driver B, I'm filing a lawsuit. And I don't get to litigate that case. I don't have standing because I didn't suffer an injury.
That's
And
a
there's no
private-
allegation in this
You also
claim.
don't have standing because that's a private right issue, and there's no history in Georgia law or common law for you to litigate it. But if the General Assembly said, in an effort to deter, dangerous driving, we're going to allow people to sue other people who engage in dangerous driving, and we're going to reward them with attorney's fees, which is one thing you get rewarded with, and damages, except any damages you recover first need to be paid to the people who suffered the actual damages.
Right. And I think that becomes, what we're doing here is we are blurring the line between the legislative and the judicial.
Why?
Because
You
this
say we're
court,
blurring the line, but as Justice Peterson said, that we have a very low standings threshold in Georgia, except for where there is separation of powers concerns, but I don't see the separation of power concern when the legislature says, we would like to do this. We would like to call this an injury and redress it with damages.
right, but I think ultimately the question we were asked to brief is can the General Assembly create standing that does not otherwise exist under your jurisprudence? And my answer to that question is no, it cannot. This court can determine where standing is, but
Well,
only this court.
Said, I mean, the General Assembly creates standing in that sense every time it establishes a cause of action, right? Before the General Assembly, if there's no common law cause of action, you can't go to court and say, well, you know, I'm here to sue somebody because I feel like it and I would like damages. But when the General Assembly says, well, actually, we're going to create a cause of action, call it, I mean, there are all kinds of statutory causes of action and you can get damages, now you have the right to go to court and enforce that standing the General Assembly gave you.
I agree that the creation of a cause of action necessarily calls upon this court to make a determination as to who has standing to bring it.
But you want us to say when the General Assembly creates that cause of action, without any separation of powers issues of invading the General Assembly's authority, that the General Assembly can't say who gets to enforce that cause of action?
Right, that wall works both ways. Not only are you prohibited from encroaching upon their territory, they are prohibited from encroaching upon your territory to define what is a case.
Well, and look, they're also prohibited from encroaching on your territory under the Home Rule provision of the
That's
Georgia
correct.
Constitution.
And we haven't reached that because of the procedural posture below.
I don't see that in any of your responses in the trial court either. Is that a live issue in this case yet?
It has not been addressed because of the procedural posture. These cases came about on motions for temporary injunctions or emergency injunctions. In Newton County, in fact, that was the only issue pending. The court sua sponte dismissed the case. In Henry County, I think there was a motion to dismiss. But it was the motions that were the only issue raised below was standing
And sovereign immunity and the
Those are only
availability of
issues.
injunctive relief, right?
Those are the only issues that were raised below.
Okay, so there is
were-
not, at this point, no one in this litigation has questioned the authority of the General Assembly to legislate this way to the extent that it might implicate the Home Rule provision.
That's correct. I do believe there was an amicus brief in the Court of Appeals that raised
But of
a
course,
First
amici
Amendment
can't-
argument, but it wasn't. And
And
the-
of course, governments don't have First Amendment rights. They only have powers, right?
I might have to disagree with you on that, but that's not an
Governments
issue.
don't have rights. I mean, the Bill of Rights confers rights on persons, not governments.
I'm happy to address that, but my time is up.
We can end there. I appreciate the arguments of both sides. We'll try to get you a decision as soon as we can, and we'll be in recess until our June session.
All rise.